The Honourable David Parker.
Thank you, Mr Chairman. I'll make a brief contribution to this part of the debate. Mr Chairman, I think, as the Minister and most in this House will understand, is patent rights involve a trade-off that's thought to be in the society's interest, that if we enable people who make discoveries and go to the trouble of investing in the research that leads to discoveries, if we allow them a reward from their effort, then society's better off because people go to the effort of making those discoveries. And if there was no protection of the discoveries that they make that have utility, if there was no protection for them for the economic benefits that flow from those discoveries, they wouldn't do the research in the first place, and as a consequence, society would be poorer for it. We would have fewer medicines, we would have fewer discoveries in engineering across society, and we would be poorer, we would be poorer in a wealth sense and in poorer health and have worse environmental outcomes were it not for those discoveries. Now, this tension between the monopoly rights that you confer upon a patent holder to enable them to get the fruits of their labour rather than them being ripped off by someone who hasn't put the time and investment into the discovery immediately upon that discovery becoming public is dealt with in public policy sense by both limiting what it is that you can patent and limiting the term of the monopoly right that flows from a patent. And this legislation attempts to do that. Now, where you stand on how broad patents should be, or how broad what should be able to be patented, and for the period for which patent protection should exist, in part from the point of view of some countries, seems to depend on what is in their economic interest. And countries that end up owning a disproportionate share of the world's intellectual property rights as protected by patents seem to think that that justifies them from an economic sovereignty point of view, trying to push the boundaries of what can be protected and how long it can be protected for. And we see that, and we perhaps will see that playing out in the TPP negotiations that are underway. Now, in respect of that, I would suggest that even those who have lots of intellectual property should be hesitant to extend protections too far, because it stymies innovation even in their own countries. And if you extend patent rights too far, and I'm coming to how this is relevant in respect to the definition of computer programs and what can or can't be programmed in respect of computer programs, or indeed in respect of DNA code, if you go too far, you stop other people innovating. And one of the concerns that the New Zealand computer industry has, both in terms of patent law and copyright law, is that if the New Zealand government goes too far in adopting what countries like the United States want, and to which the Australians actually agreed in their free trade agreement with the Americans, notwithstanding their Treasury advice that it came at significant economic cost to the Australian economy. If you go too far down that way, you actually block innovation in your own country, because the computer programmers that might want to be designing a software solution or writing a software solution, for example, in medical technologies, which New Zealand's very strong in, could be blocked from doing so because their freedom to operate is effectively prevented by the terms of patent law protecting prior patented inventions that have been, prior inventions that have been allowed to have been patented under patent law. So if you push it too far, that's the consequences, and then the societal outcome of that is that you actually have less innovation, and it runs in the opposite way of what is the underlying intention of patent law. So this is the balance we're trying to strike, and in my opinion, we always need to be very wary about those who are claiming extensions to patent rights, because their attempt to extend the terms of their monopoly right is often motivated by their financial interest rather than the societal need for more knowledge, which should be what drives patent law. So, Mr Speaker, it is with that somewhat long and complicated, I think necessarily so, description of what it is that underlies the principle that we should be judging this amendment in respect of Mr. Chairman.
Honourable David Parker.
Thank you. It is in respect of that we should be judging this amendment to clause 10A as to whether it gets the balance right, which says that, as the Honourable Leanne Dalzell has said, it tries to say that where you have some computer software that is intrinsic to the working of a mechanical device, then the fact that the mechanical device includes some software doesn't stop it being patented. Yes, I agree with that. But if you go so far as to say that source code can be protected by way of patent, this is not copyright, this is patent, then you can go too far because you can block other people innovating. Similarly, in respect of some of the lines that we have to draw around DNA-related technologies, there was a time when in the United States you could patent DNA that had been, or a string of DNA that had been decoded. There was no invention in that step. There was nothing that should have been patentable in there. It was essentially a list using a technology that might have of itself been patentable, and the patentable technology that allows you to read the list might very well be properly patentable, but the list that you read in DNA as a consequence in other DNA when you're reading that should not be patentable. Now that particular branch of the law was closed off even in the United States when they realised the folly of their way and cut back on patent rights, but it's an example of how you need to be very careful about not extending the scope of patents in a way that does not meet the underlying purpose, which is to stimulate investment in research and development that increases the sum of knowledge in society in a way that wouldn't otherwise occur, so justifying the time-limited monopoly rights that are conferred because, as a society, we're better off. And I'd like the Minister to explain how, on the basis of that principle, he's arrived at this amendment that he proposes to clause 10A in respect of computer programs.
Members, we come to the vote on Part 1. First, we have the Minister's amendments to SOP 120 as set out on SOP number 237. The question is that the Minister's amendments be agreed to. Those of that opinion will say aye. To the contrary, no. The ayes have it. A party vote's been called for. I'll ask the clerk for a party vote.
New Zealand National.
59 votes in favour.
New Zealand Labour. 34 in favour. Green Party.
14 opposed.
New Zealand First.
7 in favour.
Māori Party.
3 votes opposed.
Mana.
1 vote opposed.
Act New Zealand.
1 vote in favour.
United Future.
1 in favour.
Brendan Horan.
1 in favour.
Any other votes?
Members, the ayes are 103, the noes are 18. The Minister's amendments are agreed to. The question now is that the Minister's amendments, as amended, set out on SOP number 120 be agreed to. Those of that opinion will say aye. To the contrary, no. The ayes have it. A party vote's been called for. I'll ask the clerk for a party vote.
New Zealand National.
59 votes in favour.
New Zealand Labour. 34 in favour. Green Party.
14 opposed.
New Zealand First.
7 in favour.
Māori Party.
3 votes opposed.
Mana.
1 vote opposed.
Act New Zealand.
1 vote in favour.
United Future.
1 in favour.
Brendan Horan.
1 in favour.
Members, the ayes are 103, the noes are 18. The Minister's amendments as amended are agreed to. We now move to Materia Ture's amendments set out in SOP number 348. The question is that the amendments be agreed to. Those of that opinion will say aye. To the contrary, no. The noes have it. The noes have it. Are you calling for a party vote? You must call for a party vote at the time I announce the result, otherwise I will move on. A party vote's been called for. Ask the clerk for a party vote.
New Zealand National.
59 votes opposed.
New Zealand Labour. 34 opposed. Green Party.
14 in favour.
New Zealand First.
7 opposed.
Māori Party.
Sorry, point of order.
A point of order, Louise Upston.
Sorry, in the discussion earlier, I lost the number of the SOP. Could you clarify for that, please?
We're on Materia Ture's amendment on SOP number 348.
Thank you. So, Māori Party opposed. 3.
3 opposed. Mana.
1 in favour.
Act New Zealand.
1 opposed.
United Future.
1 opposed.
Brendan Horan.
1 opposed.
Members, the ayes are 15, the noes are 106. The amendments are not agreed to. The question now is that Part 1 is amended stand part. Those of that opinion will say aye. To the contrary, no. The ayes have it. Members, we now move to Part 2. This is debate on clauses 12 to 29. The question is that part... A point of order, Materia Ture.
Thank you, Mr Speaker. I just would seek your advice as to why my amendment to Part 6 of the bill was put during the vote for Part 1.
I'll just have to seek some clarification. The answer is because it has amendments to clauses 4 and 6, which forms part of Part 1.
Point of order, Sue.
Materia Ture.
So does that mean, Sue, that the amendments to clauses 200 and something, I can't recall the exact number now, will be put during the vote on Part 6?
That is correct.
Thank you, Mr Speaker.
The question is that Part 2 stand part. The call goes to the Honourable David Parker.
Thank you, Mr Chairman. I want to address respectfully Stephen Browning's amendment or proposed amendment to Clause 15 in Supplementary Order Paper 124 and explain why it is that the Labour Party will not be favouring that amendment. Thank you for consulting us about it and the way in which you've gone about that. The explanatory note to the or the letter that came with the supplementary order paper